It was supposed to be just another morning at the Supreme Court. The docket was packed, a stack of cases lined up for consideration. But one case stood out, a federalism dispute that had crept through the lower courts, mostly unnoticed. It hadn't made the headlines. It wasn't charged like the battles over abortion or gun rights. Yet to constitutional scholars, it carried the weight of a case that could redraw the line between state and federal power. At precisely 10 a.m., the justices took their seats. The air in the courtroom felt heavy, expectant. Most observers anticipated a routine session, until she walked in. Pam Bondi, the former Florida Attorney General, more known for her appearances on cable news than for any triumph in court, stepped up to the podium. Some scoffed, others whispered. Few in the room believed she had the mettle to stand before the highest legal minds in the country. Justice Amy Coney Barrett was among them, renowned for her incisive questioning and methodical logic. She had a reputation for slicing through arguments like a scalpel. The moment Bondi began speaking, Barrett's eyes locked on her. "Madame Attorney," Barrett interjected, barely 2 minutes in, "you're asking this court to rewrite a long-standing precedent under the Supremacy Clause. Are you suggesting that states can now override federal mandates?" Bondi paused. She didn't flinch. She didn't blink. She simply nodded, calm and unwavering. "Justice Barrett, I'm suggesting that the framers never intended for federal authority to trample over state sovereignty without limit." A soft murmur rippled through the gallery. Barrett leaned forward slightly. "That sounds more like a political argument than a legal one. This court isn't here for sentiment. We follow structure." Bondi's smile was subtle, confident but not smug. "Then let's talk structure, Justice Barrett. Article 1, Section 8, enumerated powers. Everything else belongs to the states. The 10th Amendment isn't just decorative. It's a directive." And, just like that, the atmosphere in the courtroom shifted. What started as a routine argument was becoming something else. Something sharper, more intimate. A clash not just of law, but of conviction. For the next 10 minutes, the two women traded blows, not with anger, but with precision, with intellect. Barrett pressed Bondi on the boundaries of the anti-commandeering doctrine. Bondi fired back with case law from Prince v. United States. Barrett challenged the limits of cooperative federalism. Bondi answered, citing NFIB v. Sebelius with a fluency that made heads turn. But there was more to it than citations and precedent. The room felt it. This wasn't just a legal argument. It was a duel, a battle of minds, a test of will. Even the justices who usually jumped in, Kagan, Alito, Sotomayor, fell, silent, watching. It was rare, almost unheard of, for a single exchange to hold the room like that. And still, the question hovered. Could Pam Bondi, the media personality, the outsider, the political appointee, actually sway the legal thinking of a sitting Supreme Court justice? Could she, in this moment, shift the doctrine itself? The final answers wouldn't come that day. But something irreversible had begun. A quiet transformation was taking place in real time. What followed would test the limits of argument, intellect, and constitutional faith. And by the end, what Pam Bondi said wouldn't just leave a mark on that courtroom. It would leave a mark on American legal history, but you'd have to stay until the very end to understand why. When Bondi's final words fell into the room, the silence that followed wasn't empty, it was electric. It was the kind of pause that only happens when something truly unexpected disrupts a place built on predictability. Justice Barrett narrowed her eyes, shifting in her chair. "Miss Bondi," she said quietly, "even if we accept your premise that the Constitution limits federal overreach beyond what precedent suggests, how do you reconcile that with McCulloch v. Maryland? Chief Justice Marshall was clear. The power to tax involves the power to destroy." Bondi didn't break her gaze. She was just getting started. "I don't dispute McCulloch, Your Honor," Bondi said evenly, "but it's not a blank check. The same Chief Justice Marshall also warned against an indefinite expansion of implied powers. If Congress can do anything merely because it's convenient, there's no limit to federal power. That's not governance. That's domination." "Justice." Barrett tilted her head, intrigued. "Strong words. But we don't overturn decades of established doctrine just because the language is evocative. That's true, Bondi conceded. We overturn it when it's wrong. A sharp intake of breath echoed from the gallery. One of the clerks glanced up from his notes. Even Chief Justice Roberts looked momentarily surprised. Still, Barrett didn't flinch. She had heard brash statements before. What mattered now was whether this one could be substantiated. What exactly are you proposing in its place? Barrett pressed. No dancing around theory. Give me your framework. Bondi didn't hesitate. We call it the Bondi test. 3 prongs. First, whether the federal action falls squarely within an enumerated power. Second, whether the state has a compelling constitutional interest in resisting it. Third, whether there exists a historically recognized balance point that has been violated. Barrett raised an eyebrow. So, a balancing test? Not quite, Bondi replied. It's more like a firewall, a structural safeguard. It assumes sovereignty belongs with the states unless the Constitution clearly says otherwise. You're asking us to flip the burden, Barrett observed. Yes, Justice, Bondi said calmly. Because right now, states must prove they can say no. I'm arguing that the federal government should have to prove it can say yes. For a second, no one spoke. This was no longer a commentary. It was a thesis, a structure, a new way of reading federalism, coming from a voice they hadn't expected. Finally, Justice Kagan spoke from her seat on the far left. Ms. Bondi, isn't this just another version of the 10th Amendment argument we've heard for years? Bondi turned to her respectfully. No, Justice Kagan. The 10th Amendment has been treated like a footnote. I'm proposing it be read as a firewall clause. A mechanism, not just a reminder. The words lingered in the air. Barrett tapped her pen once, slowly. She hadn't anticipated this level of clarity, or this level of challenge. She glanced down at her notes, then back up. If we were to entertain this framework, she said, it would affect nearly every federal statute tied to conditional funding. It would, Bondi agreed without hesitation. And you believe the states are prepared to shoulder that responsibility, Barrett pressed. Better than they are to carry federal burdens they never agreed to? Bondi didn't blink. Yes, Justice. Barrett leaned back in her chair. The duel wasn't over, but the ground had shifted. She was no longer interrogating a witness. She was engaged in a conversation with a peer. Around them, the audience seemed to sense it too. The marble courtroom, steeped in tradition, had seen many giants. But rarely had a lesser-known advocate stood so firmly and so unapologetically before the bench and dared to redraw the lines. Whether they would accept Bondi's new framework was a question for the days ahead. But in that moment, in that room, the momentum no longer belonged to the court alone. It was balanced, and Pam Bondi was still speaking. The room felt different now. Not louder, not tenser, just altered. As Bondi stepped back for a brief pause, the justices exchanged glances. These were seasoned legal minds, trained to keep emotion hidden. But even the smallest changes, a furrowed brow, a pen set down early, meant something. Pam Bondi had entered this courtroom as the underdog. Now, she stood in the middle of the nation's most powerful chamber, dictating the pace of the conversation. Justice Barrett refocused. Your framework assumes historical clarity, she said. But history is contested. For every precedent you cite, the federal government has a counterpoint. Bondi nodded. And that's exactly the problem. We've stopped asking what the Constitution actually says, and started asking what it can be stretched to mean. Justice Sotomayor broke in. But isn't some flexibility necessary for modern governance? Flexibility, yes, Bondi said softly. But distortion, no. The moment hung in the air. If we allow federal convenience to override constitutional structure, we no longer serve the people. We serve the system. So Mayor paused, almost as if rethinking her line of questioning. It wasn't often that someone managed to bridge constitutional theory with plain-spoken clarity. Barrett jumped back in. Let's say the court applies your Bondi test, hypothetically. What happens to the Affordable Care Act? To environmental protections? To civil rights legislation? They stand, Bondi said quickly. If they meet the test. I'm not calling for chaos. I'm calling for accountability. The word echoed louder than she intended. Accountability. It landed like a bell, even though Bondi's voice hadn't risen. She didn't need volume. She had momentum. Barrett tapped her pen again, slowly this time. Not out of habit, out of calculation. Bondi pressed on. Federal power should never rely on state submission. If the federal government wants states to comply, it should win the argument fairly. Not by coercion, not by conditioning funds, not by legal fatigue. Somewhere in the gallery someone scribbled a note. A law student, perhaps, or a journalist, who'd stumbled in for what was supposed to be a procedural day. They'd walked into a courtroom and were now witnessing a moment. Barrett leaned forward. You talk about fatigue, but law is built on layers. We don't tear them down because they're heavy. No, Justice, Bondi said. We tear them down when they've grown so thick we can't see the foundation beneath them. And just like that, silence returned. Not the awkward kind, the potent kind. Barrett didn't respond right away, nor did anyone else. That metaphor, it stuck. Even the junior justices, who usually let the veterans lead, shifted in their seats. Justice Kavanaugh looked up. Miss Bondi, what you're saying would require this court to return to something close to originalism. Bondi turned to him. Not just originalism, structuralism. There's a difference. I'm not asking the court to imagine what the founders would say. I'm asking it to enforce what they wrote. The line wasn't dramatic, but it was sharp. That distinction, originalism versus structuralism, wasn't lost on anyone in the room. And it hadn't been said by a justice. It had come from her. Pam Bondi, once seen as a political ally of governors and a familiar face on cable news, had suddenly become a constitutional voice that couldn't be ignored. The court didn't know what to do with that, yet. But outside the room, the ripple had already begun. Clerks would talk, journalists would whisper. And when the audio was released, legal scholars across the country would play it again and again. How had she come up with the Bondi test? Who helped her write it? Did anyone see this coming? But the more urgent question, the one the court had to face, was simpler. Was she right? The argument wasn't over. The toughest questions were still ahead. But in a courtroom where words usually followed precedent, Pam Bondi was creating one. Justice. Barrett wasn't one to yield easily. She had listened, absorbed, calculated. But now she leaned in. Not just physically, but strategically. Ms. Bondi, she said, her tone cooler now. You've painted a compelling picture of constitutional limits. But isn't that exactly the kind of reasoning that allowed states to justify segregation in the past, when federal power was the only tool strong enough to guarantee rights? There it was. The line no one wanted to touch. The historical landmine. And Barrett had stepped on it deliberately. The gallery sat up straighter. Bondi's next sentence would define how she'd be remembered. Not just in this case, but in legal circles far beyond. She didn't blink. Justice Barrett, she began. Federal power was crucial when states violated individual liberty. But my argument today isn't about stripping the federal government of that power. It's about preventing it from using that power when liberty is not at stake. But convenience is. Barrett didn't flinch. But who decides when liberty is at stake? The states? No, Bondi replied. This court? The answer landed clean. Barrett stared at her for a moment. It was a rhetorical trap, but Bondi had diffused it without flinching. She reinforced the court's authority while narrowing its reach, elegant yet firm. Still, Barrett wasn't done. Let's get specific, she said. Take the Clean Air Act. Suppose a state challenges new EPA limits. Under your test, the federal government argues that air pollution doesn't stop at state borders. Is that a compelling enough interest? It might be, Bondi said. But the government would need to show two things. First, that the regulation is necessary to achieve an enumerated goal, and second, that the state cannot meet that goal through its own means. If they can't meet that burden, the law fails. If they can, they win. That's the test. It's not pro-state, it's pro-balance. Justice Jackson now joined the exchange. But doesn't that invite chaos? 50 different standards? A fractured system? Bondi turned to her, measured. Chaos already exists, Justice Jackson. It's just managed by threat, by withholding funds, by conditioning access. I'm offering clarity, not chaos. If a state wants to go further than the federal minimum, let them. If they want to opt out, force them to justify it, but don't force them to comply by default. That word again. Force. It wasn't accusatory. It was descriptive, and it rang. Barrett tapped her fingers once more. The silence that followed wasn't hesitation, it was reconsideration. Pam Bondi wasn't dismantling federal power. She was reframing it, turning it sideways so the court could see something it hadn't noticed in years. Not weakness, distortion. She argued that America hadn't become too decentralized but too comfortable, that the Constitution had been stretched to cover every inconvenience, and that maybe, just maybe, it was time to start reading it again, with precision, not presumption. Barrett closed her notebook gently. Thank you, Miss Bondi. That'll be all for now. Bondi nodded, calm and composed, and stepped back. But the storm she had stirred wasn't over. In fact, the most difficult part had just begun, because now the court would have to question not just what had been argued, but why it had never been argued this way before. The counterstrike had come, but Bondi had absorbed it, and something in Justice Barrett's voice, barely audible, sounded less like dominance and more like respect. When Pam Bondi stepped back from the lectern, the air in the courtroom didn't settle. It sharpened. Even from the spectators' gallery, you could feel it. The subtle straightening of backs, the pen that paused mid-note, the ripple of awareness that something had just clicked. For the justices who spent their lives parsing language and wrestling with abstract frameworks, clarity was a rare and treasured thing. And in the past 40 minutes, Bondi had delivered not just clarity, but precision wrapped in principle. Chief, Justice Roberts cleared his throat. Miss Bondi, he said, glancing toward the clock. The court appreciates the clarity of your responses. Before we hear from the Solicitor General, are there any further questions? There was a pause. A quiet, rare pause. Normally a moment like this would spark a flood of questions. Last-minute digs, clarifications, legal jabs dressed as hypotheticals. But not today. Justice Alito broke the silence first. Just one. Bondi nodded. You mentioned that the 10th Amendment should function more like a firewall than a reminder. Are you suggesting it has been judicially neutered? Bondi didn't hesitate. I'm suggesting it has been judicially ignored. Alito's eyes lit, just slightly. Bondi continued. The 10th Amendment isn't passive. It's not ornamental. It's the Constitution's final word on sovereignty. It was placed at the end of the Bill of Rights for a reason, because it undergirds them all. Justice Gorsuch leaned forward, his interest clear. She leaned in slightly now. Yet this court has historically struggled to apply it consistently because it has treated it as commentary, not a command, Bondi said. I'm asking the court to see it for what it truly is, a structural boundary, a line, not a suggestion. Her voice carried no flash, no theatrics, just a deliberate calm. That calm had become contagious. Even Justice Kagan, known for her quick and pointed questions, had fallen quiet. She wasn't surrendering, she was focusing. The justices weren't agreeing with Bondi outright. That wasn't how this court worked. But they were doing something far more important. They were listening, uninterrupted. Barrett folded her hands on the bench, her eyes on Bondi. No longer skeptical but curious, respectful, maybe even admiring. Whatever Bondi's politics or public persona, none of it had followed her here. In this room, she wasn't a talking head or a partisan voice. She was a jurist, presenting a new constitutional lens, a usable alternative. Outside the courtroom, analysts were already refreshing their screens, reading Bondi's three-pronged test aloud to gathered reporters. Inside, the Solicitor General was readying himself. He knew what had just happened. This wasn't going to be a routine rebuttal. He would have to show not just that Bondi's framework was flawed, but that it was dangerous. Before he could take a single step to the lectern, Justice Thomas spoke up in his soft, deliberate voice, turning toward Bondi. Miss Bondi, do you believe this court has the courage to reset the scales? She met his gaze calmly. I believe this court has the obligation to. Silence again. No coldness in it, just a reverent stillness, the kind that comes before a shift. In that moment, the question wasn't whether Bondi belonged here. It was how long it would take before her framework outgrew the case itself. The silence finally broke when the Solicitor General rose. He adjusted his tie and stepped to the podium, looking ready, not rattled. He had argued here a dozen times. This wasn't new ground for him, but the map had changed. Bondi hadn't just made an argument. She'd redrawn the landscape. "May it please the court," he began. "What we've heard today is a clever repackaging of a long-rejected idea, a state-centered model of governance that would fracture the foundation of our national government." His tone was immediate and dismissive. He wasn't going to tiptoe around Bondi's performance. He would attack it head-on. He continued, "The federal government is not a guest in this union. It is a pillar. If this court endorses a test that forces the government to repeatedly prove its own legitimacy, we don't get federalism. We get paralysis." Justice Barrett cut in. "Counsel, no one's disputing the need for federal authority. The question is how far it extends when the Constitution is silent." The Solicitor General nodded. "That silence has been interpreted by this court for over a century. Broad authority upheld in areas like commerce, education, healthcare. And yes, sometimes overreach has been struck down." Barrett's voice was even. "Lopez, Morrison, NFIB. This court has drawn lines before." "Yes," he said, "but those were surgical decisions. What Ms. Bondi proposes is systemic revision. Justice Alito now,